So I want every participant to actually say that they can hear me.
I can hear you.
I can hear you.
I can hear you, sir.
Okay. I can no longer see you anymore. Michael, are you just joining us?
No, sir, I joined earlier.
Okay. Please put on your video camera so I can see you guys. I can't see you guys right now.
Okay, sir, I'm coming, sir.
So let's start with the first thing. Your Bomba and Dewan should be beside you because most of the answers that I'll be giving to you, I'll bring them from the Bomba and Dewan. So we are basically starting with question number 1. What year is this? What year MCQ is this?
I think it's 2025, sir.
Okay. Backlog set. Yeah, 2024, 2025. Okay, that's fantastic. So you all can still see my screen, correct?
Yes.
Okay, so I'm just going to read it from the screen of my laptop. So this is 2024, 2025 law school questions, and we are going to take them one after the other. I have taught you guys, and I'll continue to teach you guys that the best way to actually answer law school past question is to assume that potential um, every potential option is correct until you provide a valid reason why the other ones are wrong and the one that you are choosing is correct. So if you have A, B, C, D, E, A is correct, B is correct, C is correct. That's the disposition towards it. You know why? Because when you are reading a question and then you see when you see A is most likely, oh, this looks very correct. And then you just choose it without looking at the others because you already have the mindset that A is correct because that was probably what you were thinking about. But if you are giving every option the benefit of the doubt of their correctness, then by the time you get to probably D, you will see something that, oh wait, I didn't think about this. Could this also be correct? And then you now go back to the question and find a justification for why A should be chosen over D or D should be chosen over A. Do you understand what I'm saying? Do you guys get me? So that is the mindset to solving past questions, solving the MCQs. You don't just go to the MCQs and then you just see A is likely to be correct because law school will intentionally give you something that seems correct as A or B. They know what they are doing. That's number one. Number two, when you read question number 1 and you make a decision, even though you are not sure about that decision, look at question number 2. If it's a follow-up of question number 1, then look at how it is couched. You are likely going to see the answer to question number 1 in question number 2. If you get my point. Because we had instances like this in this MCQ, and I'm going to lay it down for you. But let me take it one step after the other. I believe that the question with respect to question 1 to 5 are things that you have been taught in school, so I don't expect anything to be surprising to anybody, right? So we have Chuk Folashade. This is the fact. Chuk Folashade sued Mary somebody. That name, Hundeton. Oh, I'll be waiting with that. At the High Court of Lagos State for the sum of 100 million naira, being the general damages for defaming a character in her letter of January 31, 2025 to Newsmine Publications Limited, a print media outfit. After the close of evidence and hearing of the addresses, the court entered judgment in favor of Chooks for Lashade. Question 1. Now, I had already told you as well that during your bar finals, when you are reading this block that is usually put up, you should read it as fast as possible, because sometimes they are just there to slow your pace and wasting your time without them having a direct bearing on the question that you are being asked, right? So some of the things that you need to just take note of is, what is the substance, the cause of action. In this case, you can see it's defamation. Who are the parties here? You can see that there is a company, there is another person who has been said to defame, and then there is a plaintiff. Where did it happen? It happened in Lagos. Did they say where it happened? Yeah, that in Lagos. That's where they are suing. And then lastly, how much are we talking about here? 100 million. Those are the things you need. And once you've gotten that, that's good. You don't need to waste your time and start looking at the names of the people and all that. No. The parties, the amount, the cost of action, and where, the place. Those are the things that are important when it comes to civil questions. Unless you go into the questions now, let's say number 1, 2, 3, and then you now realize that they are asking something that they usually ought not ask, right? Then you now go back to the block again to look at what's up. Do you understand? So, question 1, Chooks Folashade wants Newsmine Publications Limited to produce the original copy of the letter written to it by Mrs. Mary at trial. How can she get the letter? Now, this question is actually very confusing, but I'm going to pick people to answer it. Let us start with H.O. Roberts. H.O. Roberts, what's your answer to question number 1? And why? The options are A, notice to produce, B, subpoena, C, summons to produce, and D, a written request for discovery of documents. H.O. Robert, what is your answer? Is H.O. Robert here? You see the reason why I said people should have their camera on, because I cannot interact with you because I don't even know if you are here. Have your camera on. I can see Precious. She's definitely here. I can see Esther definitely here, but I can't see you. Please put your camera on. I only talk to those people who have their camera on for us to have that interaction. So yes, Robert.
Said A because
Yeah.
I feel it's used when somebody is in possession of primary evidence, but you have the secondary.
What did you say the answer is?
A. Notice to produce.
Okay. You feel it is used
when somebody is in possession of primary evidence.
Notice to produce is gotten from what part of the Evidence Act?
91 and 89, I think. 89 makes reference to 91, I think, yeah.
Is the Evidence Act with you?
Not very handy, no, it's not. Okay, wait. It might be. Hey, it is. Hey, it's 91.
Yeah. I'm not saying that it's not 91, but I want you to look at it in the context of the question that has been asked. The original, right, of a document is to be tendered. Now, when I looked at this question is very confusing, right? I believe you know why it is confusing, right? Does anybody have a contrary opinion, by the way, before I talk about the likely answer? Does anybody have a contrary opinion as to whether or not is notice to produce? Yes, Precious.
Yeah, my answer was different though. Not because I know what I'm doing, but because I did this elimination method, and so let me go look at the options again. Sorry, I'm going back to the question so I can see the options. Why I picked it.
Okay, let me go to the questions. You can see my screen, Abby.
Yes. Okay.
Okay, so I'm at the options.
Okay, so I know subpoena is not for documents. Someone to produce. To be very honest, I've not heard of that before. Notice to produce. It did not just seem like it. It seemed like the answer was D. So I picked D. Oh, this is where.
Now, the reason why D is not the answer is because it's a written request for discovery, a written request for discovery of documents. That is done during PTC, pre-trial conference. The question said, look at the question, and this you have to use the question to answer. Folashade wants Newsmine Publications Limited to produce the original copy of the letter written to her by Mrs. Lori at trial. So here we are talking about what are the means of getting the original document at trial, but that written request that you have made allusion to as D can only be done with PTC. That strikes that out. Do you understand, Precious? You know what PTC is, Abi? What's that thing called? CMC, Case Management Conference in Lagos, I think. It's CMC in Lagos and PTC at Abuja. Right? Good. So
Yeah.
that's where you do that. So that leaves us with three options: notice to produce, subpoena, and summons to produce. Definitely, if you are a civil litigation person, you will know that there's nothing like summons to produce in our courtrooms. Nothing like that. It may be in criminal, but not here, right? So naturally, summons to produce, like you have said that you have never heard anything like that before, is definitely struck out, right? So there's nothing like summons to produce. Good. So now leaves us with two things: notice to produce and subpoena. Now, the reason why this question is a little bit difficult is because both of them, it is during trial that you are going to tender a document, the original of a document. You are going to seek for it, right? Now, how do you do your notice to produce? Your notice to produce is usually pleaded in your statement of claim, where you put the other party on notice to produce. But the problem is this: when you put the other party on that notice to produce, you can only argue. You cannot force the person to bring it. You can only argue. At the end of the day, there are two things that the notice to produce does for you. Two things, right? And I want to put this in the context of law school, so I don't start arguing practice, because there's always a thin line between law school and arguing practice and how to be a good litigation lawyer. Now, there are two things that notice to produce does. Number one, it gives you the right to tender the secondary evidence of a document. Why? Because the other party is put on notice to tender the original. The only thing it does is to put the other party on notice to tender the original. It does not force the other party to tender it, to bring it. It only puts the other party on notice to tender it, so that you, who naturally, by virtue of Section 86, you cannot tender the secondary evidence of a private document, right? You can't tender the secondary evidence. If it's a public document, the means of tendering it is through a certified true copy, a CTC. That's for public documents. But for private documents, the Section 86 will tell you that you are supposed to tender only the primary evidence, which is the original, right? That's very good. Now, you don't have the original. The other party has the original. What do you do? What you do is to give a notice to produce. The notice to produce does two things for you. Number one, it gives you the permission to circumvent Section 86, which means that you can now tender the secondary evidence if you have laid proper foundation as to where the primary evidence is, and you have put the other party on notice to produce the primary evidence. That's number one. Number two, it helps you activate the provision of Section 167 of the Evidence Act with respect to withholding evidence, because when you have been put on notice to produce and you do not produce the original, it will be construed against you that the reason why you did not produce that original is because it's going to be detrimental to your stance. Those are the two advantages of a notice to produce. But when you are saying that you want the original to be tendered at trial, if you want it to be tendered, what you need is a subpoena ducis tecum. They intentionally did not put that there. What is a subpoena ducis tecum? Can somebody tell me?
It's like a subpoena telling someone to come and tender just a document. They just come to tender
Exactly.
document.
What is the opposite? What is the second type of a subpoena that exists?
Subpoena ad testificadum.
Yes, subpoena ad testificadum. What is the third type of a subpoena that exists?
Subpoena ducis tecum et ad testificadum.
Yes, very good. I would have said they should clap for you, but we are in our houses, so sorry about that. Now, he's very correct. There are three types of subpoena. Subpoena ducis tecum, which is that you want the person to come and tender documents. Subpoena ad testificadum, which is that you want the person to come and give testimony. And you have subpoena ducis tecum et ad testificadum, which is you want the person to both come and give testimony and to come and tender document. Those are the three types of subpoena that we have. So if we are going back to the question again, go back to that question. The question says, you want them to produce the original of the letter at trial. If you want them to produce it, it should be by subpoena. It should be by, if you, like, because a notice to produce just puts them on notice. It doesn't force them to produce it. The notice to produce tells them, and it gives you the ability to tender the secondary evidence, because now that you have put them on notice to produce, now you can tender the secondary evidence. And also you can argue section 167 against the party, right? That is what we do when we talk about notice to produce. Just give me a minute. Now, I need somebody to go to, I don't know if you are with your Evidence Act, but if you go to section 167D, section 167D, the court, it will tell you that if you read the last part of section 167, the court may presume that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. Evidence which could be produced but is not produced would be, if produced, be unfavorable to the person who withhold it. That is called the doctrine of withholding evidence. You activate this doctrine in your statement of claim when you put the other party on a notice to produce through section 91. That's all you can do. So there are two things that notice to produce does for you. In fact, notice to produce gives you the ability to tender the secondary evidence. Notice to produce gives you the ability to activate section 167 of the Evidence Act to use the doctrine of withholding evidence against the other party. But does notice to produce ensure that the original copy is brought before the court in trial? The answer is no. But what ensures it? What is that thing that if you issue it, that person they don't run away? Because if you don't obey it, what is the punishment for not obeying? Can somebody tell me? The subpoena.
Contempt of court.
Contempt of court. Thank you. So if they issue a subpoena, ducis tecum to you that should come and tender a document, and you don't tender that, you don't come tender it, that's contempt of court. You must produce the document. So going back to the question again, the question said, Fuchs for yesterday wants Newsman Publications Limited to produce the original copy of the letter written by Mrs. Mary. Can she get that letter? Notice to produce is correct. You can use it, but it doesn't force Newsman to bring it. But subpoena is more correct than notice to produce, because with that you can force. If subpoena was not there, notice to produce would have been the most correct answer. I think, Robert, do you understand that explanation?
So I do, yes, sir.
Is it clear to everybody?
Sir?
was asking if the explanation
Sir,
was clear to everybody.
Can you hear me, sir?
Yes, I can hear you.
Can you hear me, sir?
I can hear you. Good morning to my life. Wow.
Okay, sir. So why I'm a little bit confused is, had it been maybe during the trial after issuing the notice to produce, the person, I cannot remember the name, Mr. Puma refused to produce the document. Then at that point, maybe the person can use subpoena.
No, you can
This
use
one
it,
here
yes.
is really
Yes, you can use both of them if you want to. I'm telling you that we are answering law school question, and we're answering in the context of what has been stated here. What they stated here is that Chief Chooks Folashade wants to get the original copy from Newsline written to it by Mary. How would she get the copy? Cannot to produce, get her that copy, yes. But if they do not produce it, it doesn't mean anything. That means you should then tender the secondary evidence. You should um, argue in your written address that the court should um, apply the doctrine of withholding evidence. But do you want it to come? If you want it to come, you use subpoena, and that is why it is most correct. Both are correct, but subpoena is most correct. Law school, like I said, everything, every answer that you are giving for the sake of law school and bar finals has to be justified. Your justification is based on the exact context of the question. Once you can get the question, you understand it, you apply it to the answer, and you will see, most of the time, you will see that there are usually two favorable answers. I am telling you, law school psychology, they are usually two favorable, but one is better than the other. There are usually two favorable answers for law school, but one is better than the other. Precious, I can no longer see you. Don't hide your face. So I can no longer see you, Precious. Robert, I can't see you. Um, and the rest. Okay, moving on. Let's go to question number 2. Now, assuming the letter had been produced at trial, this again, Robert, this should have informed you that question number 1 was subpoena. This should have given you that inkling, because they said, assuming the letter had been produced at trial by Mr. Careful Jack, the chief executive officer of Newsline Publication Limited, can he be cross-examined on the letter? Can somebody tell me what the answer is? I want to start from Precious. Precious usually has a very wonderful way of giving answers. So let us hear your wonderful answer to this one.
Let's try. My answer here was
Yes.
my answer here was A.
The answer here was what?
A.
A, because he's a competent witness.
Yes, so that was what I picked.
Okay. Robert, what's the answer?
Well, what I picked is different from what the actual answer is. I picked A, but I just looked at the 219 section now and I saw that it's C.
Okay. Michael wasn't here previously.
I was.
You were? What
Yes,
did you
sir.
choose?
I chose C.
Okay. So yes, the answer is C. Now, if you look at C, can Robert please read section 219 for us? Robert.
He left. It seems he left.
Okay, let me just read it. Now, section 219 says, a person summoned to produce a document does not become a witness by the mere fact that he produces it and cannot be cross-examined unless and until he is called as a witness. You will see that when answering this, they were talking about subpoena ducis tecum. you are summoned to produce a document. That is prima facie subpoena ducis secu. So they said, assuming the letter has been produced at trial by Mr. Careful Jack, the CEO of Newsmind Publication, can it be cross-examined on this thing? Now, look at the options. The first thing is that if you look at D, just anybody that chose D, they are supposed to flog you out of law school at this point because Section 84 is electronically generated evidence. So I don't even know why you are going to want to go there. That is off it. So cross out D. I understand why you would choose A because we are talking about competence of witness and he's a competent witness. Now B, because he's a compellable witness. Well, every compellable witness is competent, but not every competent witness is compellable.
It's compellable.
I hope you understand what that means, but this is not where I'll teach that one. Now, so the answer was supposed to be between A, B, and C. But the point is, if you do not understand the content of Section 219, you would not even have understood that C was in the list for the most favorable answer, right? But if you understood what Section 219 says, then you would have cancelled A and B. Because Section 219 tells us that where a person is summoned to tender document alone, that person cannot be cross-examined except he's called as a witness. Section 219. So number 2 now is piggybacked on number 1. It tells you that number 1 is subpoena, and number 2 that the person who has been subpoenaed by virtue of number 1 cannot be cross-examined except he's called as a witness. Does everybody understand? I think, Robert, does this give you more clarity? Robert is still not here. Okay, maybe he's having hard time. Folashade,
Yes, sir.
you are even the one that carried them. You are the one that carried them to court here now. No, be you be Folashade for this question. Yes, Chooks, Folashade.
Oh, sorry.
why you say sorry? Okay, so moving on. So Folashade, you are going to answer number 3 for us. Can you hear me very well?
I just realized you were calling the name of the woman in the question, not my name. So
No. I was calling you. I now related your name to the name of the woman in question. Don't run away.
okay, sir.
Yes. So, by what mode can this action be validly commenced?
I'm sorry, sir.
What's the answer? Yes. See Lola. Lola is lying down on the couch.
3, I chose.
Wait, wait. Lola is lying down on the couch. One struggle and try to solve MCQ. Lola is chilling. Lola, you are going to answer question next. You better put on the camera. Yes, Esther, what were you saying?
I chose D for number 3, and then I wanted to ask what you guys chose for number 1 and 2.
Number 1 is B, number 2 is C. Number 3, what did you say you chose again?
Okay, thank you, sir.
What did you choose for number 3? B.
D. Writ of summons along with statement of claim.
Precious. Sorry, just Precious. Precious, stop showing me your lights now and your ceiling. We want to see you. What's your answer for number 3 and justify the answer?
I picked D because.
Why? Yes.
First off, I don't think you can comment an action by statement of claim and summary judgment procedure. So A and C out of it. Then it was now between B and D, but I think this is like a contentious matter. So D, that was why I picked D.
Yeah, clap for yourself. You got this one correctly. Yes, that's the answer. You cannot commence an action by statement of claim. Well, you cannot commence an action by summary judgment procedure. The action for summary judgment order 13 of the Lagos rules is commenced actually by writ of summons. The only thing is, after commencing it by that writ, you can then bring an application that the matter should be heard summarily, right? And judgment should be given without going to trial because the facts are contentious and it is liquidated money demand, right? That's basically and thirdly and most importantly, that the defendant does not have a valid defense. It must be stated when you are talking about summary judgment order 13. Now, so you don't commence action by summary judgment, you don't commence action by statement of claim. So what are the two contentious the two most favorable options here? We have originating summons and we have writ. Originating summons accompanied by an affidavit, and we have writ of summons along with statement of claim, right? And you know that anything that has to do with defamation is contentious, right? Facts are in dispute. Therefore, according to the authority of Doherty versus Doherty, this question is going to come out in your bar finals. Cite the authority of Doherty and Doherty, please. That is the law school authority for contentious facts. There should be brought by writ of summons. So the answer here is D. Thank you, Madam Precious, for getting that answer for us. I wanted to ask Lola this question, but it's easy. I'm going to ask Lola a difficult one for her to explain for me, because she's chilling in the house while we are okay. Who has not answered the question yet? Esther, you still answer another one. Esther, question number 4 says, what order will Chooks for Lashade seek to prevent Mrs. Mary from authoring similar letters upon being served with the originating process? A. Anton-Pillar injunction, B. Interim injunction, C. Mareva injunction, D. Interlocutory injunction. What's the answer? Why? Esther Folashade?
Let me ask.
Interim injunction.
Who said interim? Interim now. Folashade?
Yes, sir. I was the one that said interim.
Explain why is it interim as opposed to others. Tell me why you disqualified others.
Because the order is going to be like she's seeking the order during the trial, like during the pendency of the conclusion of the matter.
What English is that? Esther? When do we seek for an interim?
It's when we need immediate relief, like urgent relief.
Okay. So why are you choosing interim? Okay, first of all, let's take it like this. Why didn't you choose Anton-Pillar? A. Anton-Pillar injunction.
Because
this already tells me that you have not watched my videos. Why? Esther?
not everything.
You have not watched interlocutory applications. That is definite.
Yes, sir.
That is why you cannot answer this very simple question. This question is too simple for you to be saying, what is an Anton-Pillar injunction and when is it sought for? That is very simple. Michael, what's an Anton-Pillar injunction?
Okay, an Anton-Pillar injunction is an order of court that allows an applicant to enter into the premises of the defendant to search, seize, keep in his possession the.
It sounds like saying they read this thing from somewhere.
No, sir. I actually crammed it. That's why it's like.
No cram in law school. No. Nobody said to message to cram. Oh. The thing they say you should cram is save and accept. Oh, yeah, tell us, save and accept general travels.
Save and except therein expressly admitted. The defendant denies each and every allegation of claim contained in statement of claim, as if each had been forgotten the meaning.
Set out at traverse team.
Yes, sir.
Okay. Draft the body of emotion. Take notice.
Okay. Take notice that this honorable court shall be moved on the dash day of dash at the hour of 9 o'clock in the forenoon or so soon thereafter, as counsel to the defendant/applicant may be held praying this honorable court for the following orders.
Now, couch an order as if you want an interim injunction against the Mary in this case from against Mary from writing any other defamatory letter against the applicant. So you are for the applicant. So couch the order. Another.
An order of interim injunction restraining the defendant either by himself or through either by himself or through his agent.
Okay.
Privies.
Okay.
Yeah. Or anybody claiming.
Continue.
Okay, now anybody claiming through him from so what this I should stop them from doing?
Seen any further letter that is going to defame the character of what is it called? The claimant.
Okay. From that part, from publishing any letter that might defame the character of the claimant/applicant, then and any further orders or any such further orders.
No, you have not finished drafting an interim order. There is something that is missing that made it interim.
Pending.
Exactly. Pending what?
Pending the hearing of the interlocutory. Pending the.
Yes, pending the hearing of the application for interlocutory injunction. Well, I will give you 8/10. You actually did very well coming from your head and drafting it on the spot. That is brilliant, right? So when you said that you crammed the Anton Pillar, I was like, what did they no send you? They cram up. Make I see if you see top the one where they send you, and you actually impressed me. That's very good, Michael.
Yes, I think so.
So yes, so an Anton Pillar injunction, like you were saying, you can speak now.
Okay, it's an order of court that allows the applicant to enter into the premises of the respondent or the defendant to search, seize, and keep in his possession any articles or goods which might be necessary to his case.
Okay, so if you are told to draft an Anton Pillar injunction, what court, for example, will you go to seek that injunction?
It will be the High Court
of Lagos State.
Sir?
High Court of Lagos State.
Federal High Court, I think.
Why is it Federal High Court?
Because I think Anton Pillar injunction is granted for trademarks and copyrights and such.
Okay, you are very, very intelligent. That is good. I like that. You are really answering questions. Whether I like it or not, the way I'm asking questions. You know, I always tell you that I'm preparing for bar finals, but also preparing for outside, because you also start writing application and getting interviews. So I like how you are answering the questions. It tells me that you know what you're doing, and keep it up, because I believe that after your bar finals, when you start getting your interviews and all that, you will be really very impressive. Okay, yeah. So when we are talking about Anton Pillar injunction, like he has rightly said, It is used when you want to stop when basically you are not stopping somebody, you are asking for an order of the court to give you the permission to enter another person's premises and get the goods from that person's premises because you reasonably believe that that person has kept or pirated copies of your work, right? It need not be book. It's your copyright, your trademark, your whatever, what's that thing called? Your, anything that has to do with copyright and the rest, right? You go inside, you get copies of those things, and that's what you need an Anton-Pillar injunction for. Mareva, Michael, can you tell me what a Mareva is and when we need it?
Okay. A Mareva injunction is an order of court granted to the applicant to prevent the defendant from removing from the jurisdiction or disposing of his assets within the jurisdiction of the court, which might render any judgment the claimant might obtain to a nugatory.
Very good. Thank you very much. So, a practical example of where a Mareva injunction can be used to be, former petroleum minister for in Nigeria. What's that woman's name? Can anybody remind me? The woman that traveled to Dominican Republic, bought their citizenship. Is it Alice Madueke or something? I think it's Madueke. So she was Minister for Petroleum in Nigeria. Then all of a sudden, the EFCC was chasing her about. She, did makeup and all that to the court for the court to grant bail. I wanted to ask a question now as to what are the conditions the court is supposed to look at before the court can grant bail. Can anybody answer that? Michael, the conditions the court will look at before granting bail. These are law school questions, so don't look at me as if I'm going out of topic. I told you that the MCQs are supposed to be an avenue for us to touch topics. For example, I've thought about Anton-Pillar. If you are smart, you write it down and go and read it after this class. I'm talking about Mareva. All these things, it's not just answering the question on the face of them. It is actually understanding the principles and why it could have been easier for you if you had looked at the question. You could answer that question in less than 10 seconds. Why? Because it can never be Anton-Pillar. Why? Because that has to do with copyright. It's copyright in question here. No, it can never be Mareva. Why? Because that has to do with disposal of assets. You are trying to stop the defendant from disposing his assets within jurisdiction pending the termination of the suit. Is that what we are talking about here? No, definitely it's between interim injunction and interlocutory. Why is it not going to be interlocutory? Interlocutory is pending the determination of the suit. That is when you seek for an interlocutory. But the question here said, upon being served with the originating process, what you serve most times with your originating process would be you don't serve your motion ex parte, of course, but you will serve the interim injunction, and then you will not serve the motion or notice for the interlocutory injunction, right? But we'll get to that. I've not answered the question yet. I will explain how the question is to be answered. But I'm now talking about what is a Mareva injunction, and I want to give you an example. While giving the example, I now remember that it has actually happened in Nigeria before. Talking about Alice Madueke's case and how she lied to the court that she had cancer, and then she came to the court and for the court to grant her bail, right, on medical grounds. So I'm asking, what are the general conditions the court is supposed to look at in granting bail? So can anybody tell me? And I asked Michael to tell me. So can you tell me what the conditions to grant bail is?
Yes, sir. I think one of the condition is the availability of the defendant at next trial date.
One of the conditions, availability, yes.
The severity of the offense alleged.
Two. There are a lot of.
Yes, sir. A lot.
When it comes to capital offenses, are they bailable? Are capital offenses bailable offenses?
Capital offenses.
Yes.
Yes, they are bailable offenses.
Okay, so what are the elements for capital offense for the application for bail?
Health issue. How is it couched?
Medical ground and
Medical
exceptional
ground, yes.
circumstances.
Medical ground, yes.
Okay. So in Alice Maduike's case, she said she was cancerous and all that. Immediately they granted her that bill like this. This girl, this woman, as the case is, jackpot to Dominican Republic, bought their citizenship for $1 million and never came back to Nigeria. Now, of course, she has houses in Nigeria. She has assets and all that. Knowing that she's not going to come back ever again, at least for a long period of time, she now started trying to sell off those houses clandestinely so that she would not have a need. You know, she needs money now in Dominican Republic. What is the point of being in Dominican? You can't come back to Nigeria because they will definitely arrest you on arrival. What is that the point of having multi-billion-dollar assets in Nigeria when you can sell them off and use them to buy properties in other parts of the world that do not have extradition treaty with Nigeria, right? So that, I think that was the game she was trying to play when I think EFCC caught wind of it and immediately ran to court to go and get another for Mareva injunction, telling the court, or they tried to investigate the properties that she had, and then they told the court that the court should give the order where those assets cannot be disposed of at all until the trial is concluded. So that is how a Mareva injunction actually operates. Give me a minute, please. So this case is now, we are answering question number 4, and it says, what order will Chuks Folashade seek to prevent Mrs. Mary from authorizing similar letters immediately upon being served with the originating process? You know, when we are talking about service of the originating process, I don't like the way this question is couched, because it is couched in a way that brings confusion, right? But if they ask you, look at the way they couch the question. What order? Not what application will be served, though. What order? Now, of course, when you are looking at that question, we have interim injunction, we have interlocutory injunction. Can interlocutory injunction, could it have been gotten without the defendant being put on notice? Is it possible?
No.
What order can you get without the defendant being put on notice? Definitely an interim injunction. Do you know that? That's the reason why interim injunction is the right answer. Because the question says, what order, not what application will be served with the originating process. What order will be served? So we have, I think I mentioned this earlier before, that we went to court to get an ex parte order against the company in Dubai. And we got the order. We looked at all the ingredients of an injunction. We got the order, the ex parte injunction. It's an interim injunction actually against that company. And we served the injunction, although now we are seeking leave to serve the, what is it called? The originating process out of jurisdiction. You know, you need leave to serve it is out of the country. I hope they taught you that one.
Yes.
Good. It is only when it is within Nigeria that you don't need leave to serve. You just need an endorsement in the process. I hope you know that.
Yes, sir.
According to the SCPA and relevant parts of the rules, you just need an endorsement within Nigeria. But if it is outside Nigeria, you actually need leave of court before you can serve that process. And we are in the process of getting that leave so that we can serve the originating process and as well as the order. So what you serve is actually the order and not the order of interim injunction and not the order of interlocutory. You cannot serve the order of interlocutory because the other party ought to have been on notice before an interlocutory injunction is gotten. Do you understand that? Is that clear?
Yes, sir.
Yes, sir.
Okay, very good. Question number 5. Question number 5 is too easy. I want somebody that can get it. I think it's Priscilla that is good morning my life.
Yes,
Good
sir.
morning to my life. Why are you good
Yes,
morning?
sir.
I don't know. What was the concept behind you naming your Zoom good morning to my life? You just felt like,
Sir. Yes, sir.
okay, no problem. Please answer question number 5 for us. The order sought in 4 above may be extended by the determination of the suit by an application for what?
Interlocutory injunction.
Why interlocutory injunction? What's stay of proceedings?
Stay of proceedings is used maybe to put a stop to a proceeding. Maybe if you want to go on appeal before the determination of a case, it means there is no judgment to deliver on that case. Maybe there's an interlocutory application, so you want to apply for stay of proceeding pending the determination of the court of appeal.
What you want to say is that there's an interlocutory judgment or an interlocutory ruling which you want to appeal
Yes,
against. So it's an interlocutory appeal.
yes,
Do
sir.
you understand? It's an interlocutory
Yes.
appeal. Yeah, you are very correct. Stay of execution.
Stay of execution is used when there is a final judgment on a case and the aggrieved party want to go on appeal. The best thing to do is to apply for stay of execution so that at the end of the whole case in appeal, he will not labor in vain. Because if they executed the judgment, it means the appeal is of no use. So the person will apply for stay of execution of the judgment of the lower court pending the determination of the case in appeal. The court of appeal.
Okay, very correct. Thank you so much, Priscilla. Injunction pending appeal.
Injunction pending appeal. Although I've not read that far, but let me try. Injunction means to stop someone from doing something. Pending appeal meaning maybe there's an application before the court of appeal. So I can say it is an order of court stopping someone from doing something pending the determination of court of appeal on a particular matter.
Okay. Your explanation for injunction pending appeal, there is something that I need you to tell me the difference, especially when you put it together with stay of execution. Does Michael know the answer?
Like
I
the
want Michael
difference.
to answer.
Oh.
Yes. When you are talking about injunction pending appeal, there is something that differentiates it from stay of execution. Michael, do you know the answer? Wait, no, let Michael answer. Sorry,
No, sir, I
Priscilla.
don't.
Okay.
Let her
You
try
know
it.
what? I want to give that to everybody as an assignment. What is the difference between stay of execution and injunction pending appeal? What is the difference between stay of injunction and stay of execution and injunction pending appeal? So for the D now, the D is interlocutory application, interlocutory injunction, and that is very correct because what you get first is an interim injunction that is supposed to last pending the determination of the application for interlocutory injunction, right? So that is how it is. Now, wait, the order sought in 4 above may be extended up to the determination of the suit by an application for an interim injunction, interlocutory injunction. Yeah. Okay. So, Alaji, we are going to the next area. This is where I'm going to Wait, let me see if this is the difficult part for Lola. I don't mean that girl since where they sleep on top couch. This is not the difficult part I'm looking for. Difficult part is after this one. Yes, she go to answer questions. Okay, so Alhaji Akonde Koka and Engineer Dele LC are governorship aspirants of Ondo State being sponsored by the People's Liberation Party. The party held their primary elections on September 7, 2024, wherein Engineer Dele LC won the ticket to represent the party at the general election. The election was held on January 11, 2025, and the result was announced by INEC on January 13, 2025, wherein Mr. Martins, Gentle of Airlight Party, was declared winner. Now, assuming Alhaji Kinde Koka is displeased with the outcome of his party's nomination process, within how many days was he expected to have challenged the result? Assuming Alhaji Akinde Koka is displeased with the outcome of his party's nomination process, within how many days was he expected to have challenged the result? 21 days from the date of the governorship election, A. B. 21 days from the date of the declaration of the election results. C. 14 days from the date of the results of the nomination 14 days from the day the result of the nomination election was announced, and D, 30 days from the date the course of action arose. Who can tell me what the answer is here? I'm listening, oh, Michael. This one is a very easy question.
Yes, sir, but I've not yet done election matters, but I think the answer is B.
They've not taught us.
Who said it's not taught us? Thank God that they've not taught you. This is where I'll not drag Lola inside. Lola, answer the question. Lola, I'm waiting for you.
Can you hear me?
Yeah, I can hear you now.
They've not taught us so, but I'm thinking that it's B. 21 days from the date of the declaration of the election results.
What is your authority?
I don't have any authority. Like I said, I've not actually not read this topic. Like from 6 to 20, they've not taught us those topics, to be very honest. So I've not read it. So I can only guess or use
Okay,
common sense.
I want if you are with your day one, go to page 555 of day one.
Okay.
Yeah.
555. Okay. I'm there.
Okay. Now I'm going to just speak on election matters, just for us to be able to get clarity on this question. I'm not teaching election petition. I'm just speaking. Now, when we are talking about election petition, they are divided into two, right? Election petition is divided into two. You have number one, pre-election matters. Pre-election matters is governed by its own rules. Then you have post-election matters. Now, the post-election matter is the one that we all know as the election petition and all that. But there is also the pre. Before elections happen, the general elections that we all know, everything before the general election is pre. Do you understand? So Peter Obi left LP, went to ADC, now went to NDC. Everything that is currently going on is pre-election. That is what I'm saying. Do you understand that? Does everybody understand that? Okay.
Yes.
So let me read out page 555 here. There one. I want to be fast so that we can go over this. Now, pre-election matters are disputes arising from the steps from steps preparatory to election and matters which precede elections and do not fall within the grounds for which an election petition may be filed. The court has held severally that such disputes which precede an election, such as question of nomination of candidates and complaints against the electoral commission or a political parties preparatory to an election, are pre-election matters, and an election tribunal has no jurisdiction to entertain such matters. Right? If you look at the case of Okadigbo versus Emeka, they said more on that. But I want us to look at page 556. Please go to page 556. Section 84, sub 14 of the Electoral Act 2020, as amended, provides that the Federal High Court has exclusive jurisdiction to hear matters for pre-election. When we are talking about the election, the election petition matters, you will now look at, you know, for example, the governorship election has its governorship election tribunal. Then we have others which I don't want to go into, so I don't start teaching, you know, the substance of all that. But I am telling you, for you to be able to understand the election petition, understand that first there are two parts for election petition. When you are reading it and when you are answering the question, you should ask yourself, this question I am answering, is this a pre-election matter? Because again, like I said, the rules that govern them are different. And as a result, you have to first determine if it is a pre-election election petition matter, so that you can then determine the rules that we apply. Because somebody said that the answer here is 21 days from the declaration of the election result. That is applicable to election petition matters. If that person had said that, if it's an election petition matter, it would have been correct. But the answer here cannot be that, because when we look at the question, it says, assuming Alhaji Akinde Koka is displeased with the outcome of the party's nomination process within how many days? Now, the party's nomination, go back to page 555, where they once said that the court had held severally that such disputes which precede an election, such as nomination of a candidate. The question here is this nomination process. Therefore, this falls squarely, according to the authority of Okadigbo and Emeka, it falls squarely as to pre-election matters. So once you have determined that this is a pre-election matter, the next thing we are supposed to look at is how many days is it supposed to challenge the results. So what are the rules guiding pre-election matters? We then go back to 556. When we are talking about the rules to challenge it, it says by section 258 of 5 of the Constitution, ruling on preliminary objection or any other interlocutory issues touches on the jurisdiction of the tribunal or court in any pre-election matter, or on competence of the petition shall be suspended and delivered at final judgment. By section 285 sub 9, notwithstanding anything to the contrary in the Constitution, every pre-election matter shall be what? You guys following me with this book?
Yes,
I
yes.
can't hear. Okay. Now, it says, notwithstanding anything to the contrary, every pre-election matter shall be filed no less than what?
14 days.
14 days from when? Don't just say 14 days. In civil litigation, especially in election petition, you just stop at 14 days. Election petition is a time-sensitive matter. Therefore, you have to be very careful what you have said. If you look at the options here, after the days that they put from when. That's to tell you that you don't joke with election petition dates. When it comes out to your MCQ, you have to be careful, not just 21 days, yes, but 21 days from when if it comes out in your civil litigation essay, and you just put 21 days, by then you are failed. You are failed, because that's not the answer. 21 days can be anything. From when? Do you understand that? So when we are talking here, we said 14 days from the date of the occurrence of the event, decision, or action complained of. What is complaining about here is the nomination process. So it ought to be 14 days from the result of the nomination election was announced. That's going to be C. It cannot be 30 days, because that's not the answer. It cannot be 21 days for any of the two. The answer is C. I didn't say so. It's your textbook. Oh. This is what they teach you at law school. I only carry the textbook to teach you. Now, if you read further, therefore, an aspirant, where an aspirant or political party fails to complain before the Federal High Court within 14 days limit is foreclosed from complaining unless such complaints also constitute a ground for challenging an election as held in Sterling versus CPC. So in our firm, we represented LASTEC in one particular matter, one PDP matter. LASTEC is the Lagos State arm of INEC, Lagos State Independent Electoral Commission. It's called LASTEC. And when they brought the action, it was an intra-party dispute where they were saying that, oh, the person who won, whose name was on the ballot, and like the person that was announced with video evidence to show was different from the person that was his name was sent to LASEC, who is going to be contesting at the general elections. Now, that would be an example. Look at it. Unless such complaint also constitutes a ground for challenging an election. That may be an example where you will talk about complaints with respect to grounds for challenging the election, because the person who actually won at the primaries, you know that's a pre-election matter, can now extend to a general election matter where the 14 days can be jettisoned. So there's only one ground, and I want you to underline that because it's a likely MCQ question for pre-election matters. What is the ground upon which the 14 days can be jettisoned, where we are talking about pre-election matters and you bringing action within the said 14 days? It is where such complaint constitute a ground for challenging an election in itself. That's the general election. Okay, but moving on. We already know the answer to this one. I don't want to teach election petition. I just want to direct you to the relevant parts of what you are reading, right? I hope you people understand what I just explained. Do you understand it? Okay. Let's move on. I saw Precious. Okay, very good. Now, question 7. Where is the most appropriate venue to institute the stage above? I already said it. Where is the appropriate venue? I didn't hear you. Very good. What is your authority? What is your authority? Precious.
Sterling versus CPC.
No, that's not the authority. That's not the authority. Yes. Sterling versus CPC is the authority for the exception of the 14 days. The 14 days exception. Unless where it's a grant for so and so. I'm talking about the exception, the authority for Federal High Court. It is section 84 sub 14 of the Electoral Act. So if this comes out in bar finals, apart from the fact that you write the Federal High Court, you will also write section 84 sub 14 of the Electoral Act of 2022. Okay. Do you understand that?
Yes, sir.
Okay, very good. Let us move on. Now, what is the most appropriate means of commencing the action, assuming fraud or forgery is not involved? What is the most appropriate means?
Petition.
Why did you say petition?
Okay, assuming fraud or forgery is not involved. I still petition.
I did not say it's not now. I said, why did you say so?
Petition is used for election matter.
The law provides that all electoral cases will come by way of petition.
The law says that what?
Electoral cases are mainly by petition.
Is this an electoral case, madam? This is a pre-election matter. There are two different things. I just try to explain that to you now. A pre-election matter is different from a post-election matter. What you're talking about is about post-election. Those rules are different from pre-election, one of which is jurisdiction. Federal court has the jurisdiction for pre-election. For post-election, it depends on the different tribunals and the different levels that we're talking about. That each of them have their jurisdiction. When you are coming for post-election, that's general election, is by petition. For pre-election, that's the question they're asking you. You said it's petition. What is the authority that is petition? I'm waiting for someone to answer me.
What did you ask, sir?
Yeah?
What did you ask?
The election have their own movement.
I'll go with organization.
Well, I'm looking at their one to see if their one was going to put it down. Surprisingly, he didn't. Or maybe I'm the one not just taking my time.
No, you didn't state it. I already went through it too.
He didn't state what the answer is. But the answer from practice, which is why I'm very, very wary. The answer from practice, there's a reason why they said where fraud or forgery is not involved. The answer is originating summons, right? Because all you are doing is interpreting the document. The facts are not in contention, right? You are interpreting the document and all that and all that. That's basically what you're doing because it's a time-sensitive matter. The answer is actually originating summons, especially when fraud or forgery, because those are contentious matters. The burden of proof for that is higher because when you are proving fraud or forgery in a civil matter, the burden is proof beyond reasonable doubt. And you don't do that in an affidavit, which is what comes with an originating summons. And even in our LASEC matter, it was PDP's intra-party dispute, and they came by originating summons. So I know that for a fact that is originating summons. However, I want you to confirm this textbook, this Dewan's textbook, is basically a confirmation from the lecturer because it's the lecturer of law school that wrote it. So I can basically give a conclusion and tell you, oh, based on this is the answer. But since he did not put it here, please go and confirm if it's originating summons. The answer, I am 100% sure, is originating summons. I am sure. But I want you to confirm for the sake of utmost clarity. Do you understand that? Does everybody understand what I'm saying?
Yes, sir.
Yes, sir.
Okay. Now, assuming the result of the election has been challenged at the governorship election tribunal, the tribunal will be properly constituted with the following. Who knows the answer? Okay, you have not been taught. No problem. I said, who knows the answer? Question number 9. Okay, if you don't know the answer, please go to page 523 of that one. Page 523 of that one. Are you there?
Yes.
Yes.
Good. Governorship election tribunal. This is a tribunal established for each state of the federation and is saddled with the original jurisdiction to hear and determine petitions as to whether any person has been validly elected to the office of the governor or deputy governor of the state. The tribunal shall consist of what? Have you seen it?
Yes.
The chairman and 2 members. What's the authority? 285 the Constitution.
I get right.
Good. So you can see.
Yes. Can I ask a question?
Yes.
I know they've not taught us so, but so
Yeah.
for this question,
Yes.
question
9.
7, yeah,
Oh, 7.
the
Okay.
one for
It's
the
7. What's
appropriate
this?
means of no 7, the most appropriate venue to institute the action.
Yes. Yes.
So
Yes.
is it because it's a pre-election matter? That's why it's not in the governorship. That's why it is in the
I
Federal
just
High
said
Court.
that now. I just said that. Yes. That's the answer. That's why it's in the Federal High Court. Were you not
Okay.
here? Lola, you were not here.
Okay, sorry, just wanted to confirm. Thank you.
It's a lie. You did not hear it before. Don't use I just wanted to confirm to this. You people will put off
I did not
your
know.
camera. You put off your camera and be doing something else. He said, look at Precious. I
I'm
can
not
see
doing anything
Precious is
else.
seeing me. I know that yes, she's concentrating. I can see Dewa in front of her. You now, you were lying down on couch. Okay,
My
let's move
network
on.
is bad. Like it's logging me in and logging me out.
Lola. What is wrong with your network? Don't lie on MTN. Leave them alone. Okay, moving on. I'm just joking. Yeah, you are correct because it's a pre-election matter. Pre-election matters are at the Federal High Court. Do you understand? Our authority is what? Precious. You that said Salim and CPC. Our authority, Federal High Court.
Wait.
They mute yourself now.
Sorry. I think it's section
Yeah.
84 of Electoral Act. 84
84/12.
section 14.
Is it 14 or 12?
I
14.
think it's 14, no.
14. Okay, good. Learn it, put it in your head, cram it. Those are things that are supposed to cram. Okay, moving on. Yeah. So let's go on now. Upon the service, even when you look at the way number 9 is couched, it says, assuming the result of the general election has been challenged at the governorship election tribunal, it will tell you that up there, they were not talking about governorship election tribunal. We're talking about something else. So the way the questions are couched should be something that I think that we should pay attention to. Now, upon the service of the petition, which means if it has been what is it called? If it has been, when you say petition here, we are talking about the election petition that has been instituted at the governorship election tribunal. So upon the service of the petition, Mr. Martins Gentle is required to enter appearance in how many days? Now, I want us to go to, where is that? I'm using my own day one when I was in, I use a different day one. I just bought a new one. But let's go to 543. Are you at 543?
Yes, sir.
Okay. So it says entry of appearance. After service of the notice of petition and the accompanying document of the respondent and he intends to oppose the petition, he is required by the rules to enter appearance by filing a memorandum of appearance as in form TF004. Now, when you are writing this in exam, you have to write the number of the form. Don't just say memorandum of appearance as in form TF004. Why? Because when you get there, they will teach you election matters are sui generis. Sui generis meaning that they have their own rules and their own laws and they are different from every other thing. So when you say memorandum of appearance, it could be that you're talking about the memorandum of appearance of civil procedure rules of Lagos State. You need to be clear on what you mean when you say memorandum of appearance, as in form TF04. That is how to answer that question properly. And you can even go further to say, as stated in paragraph 91A of the Electoral Act, right? That is how you are supposed to answer the question in full so that you get your answer, right? But let us move on. Appearance must be entered within the time as is stated by the secretary, usually 5 or 7 days. Now look at it. I don't know why law school asks this question, because law school usually does not ask a question that has a definite answer. If it doesn't have a definite answer, law school will not ask it to eradicate confusion, right? However, when you know that the date for filing your appearance is dependent on the date as set by the secretary, which is usually 5 or 7. In this question, what is the answer? I didn't hear you.
7.
7 being A. There is no 5 here. So the most correct answer here is 7.
August.
Do you understand that?
Yes, sir.
Precious, you are squeezing your face. What's the problem? Okay,
Yes, sir.
good. So that's the answer for that. I hope everybody is getting it as we are picking it one by one and explaining in details. I hope we actually are getting it. After this, you people should go and pick election petition. Don't say that you have not been taught. Go and pick election petition. You are back. Wow, that is fantastic. Welcome. Let's go to the next question. Now, Chief Ogbongbon, which kind of name be this one? Chief Ogbongbon Dark Man. I'm very sure the person intended to say very dark man. They just try to keep it fit and proper. That is why they said Ogbongbon Dark Man sued Mr. Emeka David at the Lagos State High Court for breach of trust for misusing the title document he dropped with him for safekeeping to borrow money from banks. Chief Ogbongbon further alleges that Mr. Emeka forged his signature on the contract document and has sought for a declaration that Mr. Emeka forged his signature and 70 million as general damages. The court agreed with Chief Ogbongbon and entered judgment as sought. What steps would Emeka take to challenge the court's decision? Lola, here we come. This is appeal. You will answer these questions today. So, Lola, what steps?
What if they've not taught us to?
What concern me? Are you not a law school student? What's the answer?
Law school student.
Good. What steps will Mr. Emeka take to challenge the court's decision? Let me read it out. A. File a notice of appeal within 90 days of the delivery of the judgment, or file a notice of appeal within 3 months of the delivery of the judgment, or C. Apply for leave to appeal the judgment at the trial court in the first instance, and where same is refused, he will file similar application at the Court of Appeal within 15 days of the date of the refusal, or D. Appeal the judgment as of right within 14 days from the date of delivery. So, Lola, what's our answer? And explain why.
I have 2 answers.
So you will tell law school. Law school, I have 2 answers. Oh.
I'm always very confused because I've seen this question before, yeah. So I'm always very confused if it is 90 or 30 or 3 months rather. So
Okay.
it's either A or B. Because I just know
So
that it's
either,
like 90 because 3 months is also.
first of all, you didn't even.
Can you hear me?
Why? Yeah, I can hear you. I can hear you. First of all, disqualify D for me. Why is D wrong?
Appeal the judgment as of right within 14 days from the date. I just feel it's wrong. I don't know. Because
You just
I feel that
feel.
you should have enough time to like file your
This one is
appeal.
even being emotional. I feel you should have enough time with the law. You are emotional with the law. No, I want you to give me a logical answer. Why is D right? Give me reasons.
Why is D right or why is D wrong?
Why is D wrong, rather? Why is D wrong?
Okay. Because you have to file a lot of processes.
Jesus Christ of Nazareth. That is not that's not a reason. But okay. Precious, can you help your sister?
To be very honest, my answer was C. So I don't think I'm in the category to be helping.
You make me laugh, actually. Okay. Michael, you have a once you people put off your this thing like this, I no longer see you people anymore. Where is Michael? Your own is what?
My battery is going off. That is why I turned it off.
Okay, sorry about that. Where's Michael is not here. Okay. Now, the answer cannot be D. And Lola, this is a reasonable explanation why the answer cannot be D. It can be D because 14 days when it comes to appeal is only applicable to interlocutory appeals. It is not applicable to a judgment. Now, look at the end part of the question. It says the court agreed with Chief Gbogbo, whatever, and entered judgment. Entered judgment means that there is a final judgment. Now, I want you to go to Dewan's book, first of all. Sorry, let me just see if I can. Where is that? Okay.
Page 460.
Okay, so, yes, 460. Michael, when I was looking for you, you were looking for the page.
No, I went to something.
Okay. Now, Lola, are you at page 460 of
Yes,
appeal?
yes.
Okay. Now, the time to appeal is dependent on whether the appeal is a final judgment or an interlocutory decision. Section 24, that is of the Court of Appeal Act. Section 24(2) provides that appeal against a final judgment must be brought between how many months, Lola?
3 months
3 months
of the decision.
while
3
in
months of
respect of
decision.
interlocutory decisions, the appeal must be lodged within
14 days
14
of the
days.
decision.
that is the first thing. So the moment you read this question and then you see the court agreed with Chief Ogbongo, entered judgment as sought, it means that's the final decision. Final decision, you just go to D down. It says 14 days down. D, you cross it first. Because it's 3 months you need for final decisions and not 14 days. That is the first thing that you will cross. Right? Now, you then go to A, file a notice of appeal within 90 days of the date of judgment. You cross A. Do you understand why you're crossing A?
Yes.
Because
3
you are
months is not the
crossing
same
A.
as
Good, very good. You cross A away. That is not the answer. Because 3 months is not 90 days. The section 24 of the Court of Appeal Act says 3 months from the date of the decision. Therefore, A cannot be the answer. So now we are struggling between B and C. Now, the next question you need to ask, because C said that, C is asking the question, should you seek the leave of the court? C says, apply for leave to appeal the judgment at the trial court in the first instance. The question is, what are the grounds to appeal? When you are appealing, there are two types of appeal. There is appeal as of right, and there is appeal as of leave. There is appeal as of right, and then there is appeal as of leave, right? When you are talking about appeal as of right, what are those grounds upon which you can appeal a decision as of right? I want you to go to page 452 of your day one.
Page what?
452 of day one. Page 452 of day one. Are you there?
Okay.
Now, it says right of appeal as of right. Now, somebody has asked this question before, but I don't want to confuse you, so I will not go there. Do you know that there's a difference between right of appeal and appeal as of right? They've not taught you, so I will just confuse you if I tell you that there's a difference. You will just get confused. But there's actually a difference between
in our campus.
Oh, very good. But I don't want to confuse you, so I don't want to go there. But there's a difference between right of appeal and appeal as of right. But here, we are talking about appeal as of right. Appeal as of right, let me just give you an instance. Appeal as of right means, naturally, it's just like, let me give you an instance that maybe will stick with you as an example, right? Your daddy has told you, right, that your daddy is a very big man, is always busy and all that. And as a child, you always want to complain to your daddy for everything. And your daddy has literally told you that, see, everything you need, go to your mommy, right? It is only when mommy doesn't give it to you that you can come and meet me. Don't come and meet me first. Go to your mommy. Now, what the daddy has done by saying go to your mommy first, it is only when she doesn't give you that you can come and meet me. It means that when she has gone to meet her mom and then her mom says no, she does not need to ask for her mom's permission to go and meet daddy. She can go to daddy now as of right. Do you understand what I'm saying? So it means that
Yes,
when you go to a lower court and then for some reasons you need to go upstairs to go and meet daddy, but in this case you need to go upstairs to the court of appeal. Naturally, you are supposed to seek permission from the lower court. Please give me the permission to go up because I don't have the right yet to go up, right? Give me the permission to go up. But there are certain instances where you do not need that permission, you do not need that leave of court from the lower court or from mommy, as the case were, to go up to meet daddy. Do you understand what I'm saying? Because daddy is
yes,
busy
sir.
and all those things that they usually say. Right? Now, the question here for the sake of appeal, right, is what are those instances that once it is one of those instances, you don't need leave from the lower court. Now, if you go to day one, it tells us number one, final decisions in any civil proceedings in the high court sitting in the first instance. Final decision. The question is this a final decision? Can someone
Yes.
answer that question?
Yes, sir.
Is that a
Yes, it
final
is.
Yes,
decision?
Yes, it is.
Good.
yes, sir.
It is a final decision that was entered at the high court. Therefore, C cannot be the answer because you do not need leave. Do you see that?
Yes,
Okay.
sir.
So you can see that a lot of things has to come in play when you have to be very fast with your thinking. I do not answer these questions because I told you the mentality to answer it is everything is right. Then you now begin to justify why this one is wrong. D, for example, here is wrong because it says 14 days. This is the final judgment is 3 months. A is wrong because it says 90 days. The Court of Appeal section 24 says 3 months. C is wrong because this is a final decision and doesn't require leave. So C cannot be correct. So you see, these are the things we are talking about. Just for the sake of surplusage, look at 455 of day one. Can everybody hear me?
Yes, sir.
Yes, sir.
Okay, if you look at 455, it tells you other ground where the ground of appeal involves a question of law alone. Again, decision in any civil proceedings where it's on interpretation or application of the Constitution. Number 4, when we're talking about fundamental human rights under Chapter 4, and number 5, decision made by the High Court in any of the reasons stated therein. Now, anything, go to 456 of day one. It tells you all appeals other than that listed in 241, which is what we've talked about earlier, must be sought by the leave of court. Do you see that?
Yes, sir.
Any appeal other than what we have talked about must be by the leave. So it means that by implication, you must learn those appeals that are by right. You must learn each one of them. Section 241 of the Constitution, appeal as of right. Because anything that is not as of right would have to be by leave. You would be able to answer this question perfectly. Do you understand that?
Yes, sir.
Yes, sir.
Very good. Is Lola still here? Because she went off all of a sudden. Lola, I can't hear you if you are talking.
Somebody called me.
Oh,
Can you hear
okay.
me? Somebody called me.
Yeah.
The network was very bad. But I'm back
Okay,
now.
no problem. Oh yeah, answer question number 12. As counsel for Mr.
As
Emeka,
counsel,
For what steps will you take to prevent Mr. Ogbongbon from taking steps in respect of the judgment while decision at the appellate court is pending? Yeah. What steps?
Stay of proceeding.
I used to be lying in a shaitan regime. Where did that come from? Stay of proceeding when judgment has been
So let me
given.
read the question again. As counsel, for what step will you take to prevent from taking steps in respect of the judgment? Okay, execution, because judgment has been given. I think I remember it.
Not injunction pending appeal. Why not injunction pending appeal?
Injunction pending appeal. I don't
You know
know.
what? The answer is still of execution because here there's monetary damage. They may want to garnish their account and do other things because they have sought for 70 million naira in damages and all that. So it's still of execution of that judgment. But I've given you an assignment. Go and read the difference between stay of execution and injunction pending appeal. Our next get together of this nature, that's the first thing we're going to talk about. Priscilla, you're already tired. Yeah, sorry, eh? Is it Priscilla? No, not Priscilla. What's her name? Can't remember. She knows I'm talking to her. She's looking like what's your name? Precious. Someone you put your head back and you are looking very tired. Sorry about that. Well, you just started. You still have more to come. Moving on. Yeah. So next question. Assuming during the proceedings, Mr. Emeka Mr. Emeka's counsel rather applies to join Mrs. Chioma Unique as a defendant because she was involved in the case, but the application was refused on the ground that the applicant has not provided sufficient facts to justify the application sought. What steps will he take to challenge the decision? If you don't get this, Lola, we are going to have a problem. What's the answer here?
B.
Jesus Christ of Nazareth. Oh. Lola, is that answer B?
Sorry, let me read it again.
Oh, yeah, read it. As if a miracle is going to happen when you read it.
Let me read it again. Let me calm down. Okay.
Okay.
So, what is the question? Okay, assuming during the proceedings, Mr. Emeka's counsel applying to join Mrs. Chioma Unique as a defender because she was involved in the case, but the application was refused on the ground that the applicant has not provided sufficient facts to justify the application. So, what steps will we take to challenge the decision? No, it's not B. Sorry.
You have talked to me before.
I think it is. Sorry. I think it is D. Oh, no.
The answer is actually D. Because if you celebrate, what are you celebrating?
The thing is, it's still like looking abstract.
I understand. So the thing is this, right? We are talking about interlocutory decisions. This is an interlocutory decision.
Okay.
What is an interlocutory decision? Any decision that is not a final judgment is an interlocutory decision. Here they wanted to join somebody, and the court said, "No, I'm not joining you." It's an interlocutory decision. Therefore, your appeal, we just read it now. Section 24. Is it Section 24 of the Court of Appeals Act? Can't remember. Let me be sure.
Yes, 24-2.
So your 24 of the Court of Appeals Act just told us now that it's 14 days from the date of the judgment.
Okay.
Right? Or from the date of the I don't know why they call it judgment. I don't like law school. Law school said appeal the judgment as of right. I don't like this. The answer is
So
actually C.
can I ask
The answer is actually C, not D.
No, as of right now, that is a problem.
What did you say?
That as of right, I think
No,
it's
no,
only
no,
a
no.
final.
The answer is C. The answer is C. I didn't look at it very well. The answer is C, not D.
Okay.
Although the 14 days is correct, but I looked at it now and I was like, wait, oh, because it said appeal the judgment. It cannot be a judgment, right? It cannot be a judgment. It's an interlocutory decision. Judgment is reserved for final judgment. It is anything that comes after the entire rights and liabilities of parties have been decided. That is what we call a judgment. So when I saw judgment now, it just clicked again in my head that, oh, no, this is not the right answer. So when they say appeal the judgment is wrong. Now, the law said as of right, an interlocutory decision cannot be appealed as of right if it does not fall into some other things. So don't forget, an interlocutory decision can actually be appealed as of right if, for example, you are interpreting a part of the Constitution. It can be appealed as of right. Let's go back to day one. Now look at 455, where the ground involves question of law alone, right? It need not be a final decision. Under this head, no leave is required to appeal where the ground is on question of law alone. Once an appeal is shown to be on question of law alone, regardless of whether the court is sitting as first instance or not, or whether the decision is final or interlocutory, no leave is required. So it is possible that you are appealing an interlocutory decision, but you don't need leave because it falls under some of the grounds where you can come as of right. That's what I'm trying to let you understand now. So the next question you will ask, does this, when we are talking about joinder and they say you did not bring sufficient fact, does this fall under as of question of law? No, this is a question of fact, because they clearly stated it there that the application was refused on the ground that the applicant has not provided sufficient fact. That is as a fact. So it doesn't fall under II. Does it fall under III? Whether or not there is an interpretation or application of the Constitution, go to 455 of day one. Again, it putting any part of the Constitution here? No. We are talking about joining a party. The next question, chapter 4 of the Constitution, where it concerns any question of the provision of chapter 4. Are we talking about chapter 4 of the Constitution here? No. We are talking about joining a party, right? Then if you look at decision given by the High Court, liberty of the person, no. Injunction as appointment of the receiver, no. Decision for determination of creditor and liability of contributor, no. Decree organizer, no. Admiralty action, no. Any other case as prescribed by law enforcement. Yeah. So you can see, does this have anything to do with joinder?
No.
Therefore, it is not as of right. And D is automatically disqualified. Apart from the fact that they said judgment in D, they now said as of right. Both of them disqualifies it. Do you understand that?
Okay.
Now,
Yes, sir.
A and B is automatically disqualified because they said 90 days and 3 months. It's an interlocutory decision, therefore it's 14 days. Right? So even though the date is not instrumental to what the answer is, when I say the date here, I'm talking about date of appeal. What is instrumental is whether or not leave ought to be sought. And they said the leave of the court at the trial court in the first instance where same is refused. Sorry, apply for leave at the trial court where same is refused. You now apply for this thing. Let me go to where you talk about application for leave and time. Please go to page 460. Can you hear me?
Yes, sir.
Okay. So after we've talked about the 3 months for final decision and 14 days for interlocutory decision, in computing the time, the date of the decision is excluded. It should be noted that in terms of computing time, where an application for leave is refused by the court, a party that is at the High Court, you know that, okay, I don't think, have they taught you how to apply for leave?
Sir?
Okay.
No.
Okay, I think that's why it's confusing. So when you are to appeal, right? And it is when you are going to appeal, there are two things that you are going to ask yourself. Am I appealing as of right? No. First thing, am I appealing a final decision or am I appealing an interlocutory decision? The reason why you need to ask these questions first because of the time frame, right? The next thing, am I appealing as of right or am I appealing as of leave? If I'm appealing as of right, I just go straight to the court that I'm going to. I don't need leave. I file my notice of appeal headed in the court of appeal. But if I'm appealing as of leave, I cannot go to the court of appeal immediately. I have to first of all come back to that same court that I'm appealing against, file my application via motion or notice, seeking the leave of the court to appeal that particular interlocutory decision, because you cannot appeal a final decision as of leave. I hope you know that. It's a final
Yes, sir.
decision. You can't appeal it as of leave. So if you are going to appeal as of leave at all, it is an interlocutory decision. So it means, for example, I was in court one time at the magistrate court for magistrate Jurisu, and then there's this guy. Before I entered my firm, they brought a matter by wrong way, right? And when I came in, I assessed the file, I pointed out the errors. I will try to rectify those errors, right? We brought a matter at the magistrate court. They came by ordinary summons accompanied with affidavit. I've never heard of such error in my life. Ordinary summons. What do you file alongside an ordinary summons, Lola? What do you file alongside an ordinary summons?
For magistrate. For magistrate.
Yes.
So
Yes.
is it for the defendant? You can
What do
either
you
come
file
by
alongside common
affidavit.
documents? Hey, Jesus. So these are the people we are talking about.
You
You
file your
file
claim.
particulars of claim.
Oh,
Particulars. You file particulars of claim. So they didn't file particulars, they filed affidavit. So when I saw this mistake, I tried to rectify it. I brought an application to amend our process and we tried to amend. So they now brought a note of preliminary objection that we did not come via the right means. And then the of course it's Dieko that is arguing the application. So I mean we are going to win and we won. We won that, that phase. It was an entire phase, right, when we kept on going back and forth. And then there was something that the magistrate actually said that made me laugh. The guy that was arguing notes of preliminary objection said that the magistrate must grant it. If the magistrate does not grant it, he's ready to appeal the matter and things like that. And then the magistrate said, no problem. Whether or not I grant it. Now, there's another thing that I want you to know. When a notice of preliminary objection is granted, do you know that the time for appeal is different from when the notice of preliminary objection is refused? Do you know that?
Wow. First time hearing, sir.
Okay. So when a notice of preliminary objection is granted, it is deemed as final. Therefore, you have 3 months to appeal. But when a notice of preliminary objection is refused, meaning that the case is continuing at that same court, it is deemed as an interlocutory decision, which means you have 14 days to appeal.
Okay.
Do you see the difference?
Yes, sir.
So when it is granted that the court says, yes, I am striking out this suit because I don't have jurisdiction. If you want to appeal the order of the court, you have 3 months to appeal because it is deemed as final. That court is deemed as final, right? But if the court says, no, I am striking out your notice of preliminary objection because I have jurisdiction, I have assessed the matter and I have jurisdiction. Since the court is continuing with that matter, it is now deemed as an interlocutory decision. Therefore, you have 14 days to appeal. So,
Okay,
I was trying to explain. Yes. Okay.
So, to see if I get what you are saying, it means what determine an interlocutory application is if the case is still pending before the
Interlocutory decision.
decision, I mean. It
Yes,
means if
yes,
the case is still pending before the court.
yes, yes,
Okay, okay.
yes. If the court has not given a final judgment and the court is still sitting on the case, then whatever order the court has given that you want to appeal against is an interlocutory decision or an interlocutory
Okay,
ruling of the court.
okay,
Yes.
okay. Thank
So,
you, sir.
so the magistrate was then telling the guy that no problem. After the court gave its order was striking out the notice of preliminary objection and granting our application to amend. He then came and started saying, "No, Your Honor, you heard in law, you kidiko. I'm going to bring an appeal against this matter." She said, "No problem, I'll bring the appeal. This is not one of the instances where you have right of appeal. Therefore, you are going to bring leave, and you come to my court. I will refuse that leave." Do you see that? She said, "You will bring the leave now to appeal. And you still come to this my own court. They will refuse the leave." Do you
What if
understand
it's
that?
refused? There's no remedy.
What if it's what?
Refused. There's no remedy.
Was refused?
If the court refuse your application for leave to appeal.
Oh, there is a remedy. That's what I want to explain to you now. The remedy is
Okay.
found in 650, 460 rather. It should be noted in terms of computation of time, where an application for leave is refused by the High Court, a party has additional 15 days from the date of refusal to appeal.
Okay.
Do you understand that?
Yes, sir.
So you have 14 days to file to appeal a matter. To appeal a matter means that you file your notice of appeal, right? Once your notice of appeal has been entered, that means that you have appealed the matter. You have 14 days to do that. But if you need leave, they are going to give you extra 15 days. So 15 days from the date of the refusal of that leave, then you should file your notice of appeal. So which means that if you need leave, you should have filed your notice of appeal within the so you should have filed your leave to appeal within the 14 days. When it's
Yes.
granted, then you go up.
Okay.
Do you understand that?
Yes, sir.
Good. So this thing is not confusing, right? Because pressure is squeezing our face. Precious, do you understand what we are saying? Okay. Let us not dabble
My
into this leave
network
thing too
kind
much.
of glitched when you were talking at the beginning, so I only heard half of it.
Oh, okay. So sorry about that. This is recorded. Maybe you just go back and watch it because of our time, right? We're actually already going close to 10 o'clock and we started around 7. So this is already about 3 hours already. So I want to try to get going, right? But don't worry, I will try to, our peculiar matters, I'll try to take some of when I say peculiar, I'm talking about those 5 ending topics: appeal, what is it called? Election
Matrimonial questions.
petition, and I will try to take some of those topics before you guys go back to school. But the only problem, first of all, I do have an obligation to. It's not part of the topics that you paid for. This is me doing this out of the goodness of my heart. The ones that you paid for, you have still not watched it. Precious, have you finished watching the 200 videos for civil litigation?
No, it's only video.
I can't hear you. You are muted.
I want to ask, which day will it expire?
20th of June, sir.
Is there anybody that's finished watching it? I just started last week.
Yeah, I'm still on corporate.
Oh,
Yeah, next week,
I think
you people will know.
I'm on.
It's not easy, honestly.
I never finish it.
Okay, no problem. Let's move on. Now, during the proceedings, Chief Ogongo filed a motion to restrain Mr. Emeka from further using the title document as collateral for a loan pending determination of the case, and the same was granted by the court. What steps can Mr. Ogongo take to set aside? What's the answer? Lola, what's the answer? How is everybody quiet all of a sudden? You reach appeal now, all of them are quiet.
And let's see the question again.
Okay, let me take it up again. During the proceeding, Chief of Government filed a motion to restrain Mr. Emeka from, that is basically an interlocutory injunction, from further using the title document as collateral for a loan pending determination of the case, and the same was granted by the court. What steps can Mr. Emeka take to set aside the ruling? They've already said it is a ruling. Once it's a ruling, you know.
Yes, sir.
So, first of all, it's interlocutory, which means A and B
He's out.
is an interlocutory decision. A and B is
He's
off. Now, wait to look at D. D says appeal the ruling as of right.
right.
Now, can you see the difference between the D in 14 and the D in 13? They said appeal the judgment. You can see.
Yeah.
You can see that law school knows what they are doing. The terminologies that they use, once you see certain, that terminology, just one part says ruling, one part says judgment, that terminology alone can be used to disqualify that answer. So now they said appeal the ruling as of right. The question is, does this fall under any of the rights?
No.
That's the question. Is it a final judgment? No. Is it question? Is there any question of law here? No.
No.
Is there chapter 4 here? No.
No.
There's one more thing. Question 4, chapter 4, question of law rather. Chapter 4, application of interpretation of the Constitution. No.
Why they like this thing like this?
I don't think it falls under any rights. So I think the answer is still C, because you still need leave. But I know that there is something, they wouldn't have brought these two questions except they are gunning for something.
Just to confuse person, they know what they're doing.
Mr. Emeka, so there's a motion to restrain Mr. Emeka for using the title document as collateral and was granted. That's interlocutory. So it cannot be A and B. A and B is even out of it, because it's an interlocutory decision and the court is still going. So A and B is out of it. D is either D or C, and I don't see how this falls under any of the conditions as of right. I don't see how it falls under any of the conditions as of right. So I'll be choosing C. I don't know. Does anybody have any contrary answer?
No, maybe we'll use it as assignment.
Well, go and study the as of right very well and look at this number 14 and see whether or not number 14 has anything to do with appeal as of right. Just asterisk it and try to look at it later. Now, number 15, one of the following is not correct. One of the following is incorrect. Of appeal is not incorrect. Jesus Christ, these people are crazy, right? So one of the following is not incorrect. So which means it is correct. So one of the following is correct, right? Of the appeal to the Court of Appeal. Consent judgment is appealable. All decisions of the court are appealable. Court can never be appealed as of right. And only parties to a suit can appeal. I know the answer here, but I would like you guys to go and actually, because I want you to use this opportunity to study appeals, right? So I would give this as an assignment. Does anybody know the answer?
Consent judgment.
Saying that that's the answer, that is correct, that consent judgment is appealable.
It's not appealable.
Did you read the question? The question said one of the following is correct of appeal. So we are looking for one correct answer. If you are telling me that A is not correct, that means that that's not what we are looking for now. We are
Okay.
looking for what is correct.
Okay.
Yeah.
Okay.
So I would, Michael, please remind me
I
the
think
next
it's
time we are
zero.
meeting for this
Yes,
question
sir.
because it's an interesting question and I want you guys to go and read the PO and I want us to come back and discuss that. Then we'll go to the question for that day. Now,
Okay.
finally, Mr. Dagogo Park is a 4-bedroom duplex located at number only God knows Kijobi Street, Ikeja, GRA, Lagos State, which he let out to Chinedu Okiki as a yearly tenant commencing from May 1, 2020 at the rate of 10 million per annum. Mr. Chinedu is owing. So when it comes to recovery of premises, some things are actually very important. If it's in Lagos, then the next question you ask yourself, does it fall under the tenancy law of Lagos State or under the uh, recovery of premises law? Have you heard of that before?
Yes, sir.
What is it, sir?
I said, so what are the areas that fall under the recovery of premises law?
The area that fall under
The recovery of premises law.
I think
Yeah,
the
no.
area that is not covered.
The area that is covered by the recovery of premises law, you have Victoria Island, you have Ikoyi, you have.
They are not covered.
They are not covered.
They are not
No.
covered.
They are not covered or they are covered.
That's not section
They
3.1
are
of
not.
tenancy.
That one
No.
is GA that covered them. The conveyancing
No.
act that they are.
What are you guys saying? Are you bringing property law here? I'm talking about tenancy law.
Yes,
You know
they
what?
did not apply
Okay.
to Ikoyi.
Tenancy law does not apply to you, Papa, but
That's
recovery of
what I
premises
said.
applies to them.
I said it's recovery of premises that applies
Recovery
to
of
them.
premises applies to them. It's tenancy law that does not apply to those areas.
Yes.
Okay.
Lola, you are booting now.
I'm using property.
Don't use property. Don't make that mistake here. That is, we're not doing property, we are doing civil. I'm looking for where it is in there one, what page it is in there one. Okay, 491.
Not that much. Yes.
491. Yeah. Now look at it. Please go to 491. Is everybody there?
Yes.
Hello. Okay. Now, the recovery of premises Abuja regulates recovery of both residential and non-residential premises in the Federal Capital Territory, Abuja. The Lagos State tenancy law, amongst others, regulates the recovery of both residential and non-residential premises in the whole of Lagos State, except Apapa, Ikeja, Ikoyi, and Victoria Island. Also, the law does not apply to residential premises owned by educational institution for its staff, blah, 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 blah. I don't want to go into all that. I want to know what's. Now, look at it. Before the enactment of the Lagos State Tenancy Law, the Lagos State Rent Control and Recovery of Residential Premises Law 1997 essentially regulated recovery of premises in Lagos State and under the law. The Lagos State Tenancy Law abolished the Rent Tribunal and became the dominant law that regulates recovery of premises in Lagos State. The Lagos State Recovery of Premises Law of 1973 regulates the recovery of premises in Apapa in areas rather where the Lagos State blah 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 does not exist. Can you hear me?
Yes, sir.
Yes.
Do you know that? Interestingly, there's something about litigation that I love so much. You are going to be faced with a lot of issues There's a matter that we are handling from one of our energy companies, a very big firm, right? They also have a real estate arm of the firm, of that company. And the people who they instituted the matter against, who were their tenants, who were living in Ikoyi, very, very big artists, very, very big musicians who rented the house for, I think, about 8 to 10 million, right? And the house is at Ikoyi. Now, when we brought the action, and we brought the action in the magistrate court for order of possession and for men's profit, right? Do you know that the other party, that's the defense counsel, came, they objected to the jurisdiction of the court that Ikoyi does not fall under the tenancy law of Lagos State. Therefore, the court that is saddled with the responsibility of hearing matters cannot be brought pursuant to the tenancy law of Lagos State, but be brought pursuant to the recovery of premises law in 1973. And that under that law, it has created a rent tribunal, and therefore we ought to have instituted that matter under the rent tribunal. But if you read what Dewan said just now, this preliminary objection was a very big issue that we had to argue in court. If you read this, what Dewan said, before the enactment of the Lagos State Tenancy Law 2011, the Lagos State Rent Control and Recovery of Premises, Residential Premises 1997, essentially regulated the recovery of residential premises in Lagos State, and under the law, a rent tribunal was established. However, the Lagos State Tenancy Law of 2011 abolished the rent tribunal and became the dominant law that regulates so and so. But the Lagos State Recovery of Premises Law of 1973 regulates the recovery of premises from where the Lagos State Tenancy of 2011 does not apply, which are the 4 areas that I just mentioned. So, which means that the rent tribunal that the other party made allusion to had already been abolished, right? And he is saying no, it cannot be abolished by the Lagos State law. It has to be abolished. He just started speaking a lot of English, and I was just laughing. But coming to our law school, these points are very essential for you to understand. When you are reading a question of this nature, Mr. Dagogo Pratt, for example, when we see that, oh, this is a tenancy something, the next thing that should come to your mind is, where is it at? Is it governed by the Lagos State Recovery of Premises? Lagos State Recovery of Premises law, or is it covered by the tenancy law of Lagos State? You can see Ikeja GRA. Look at it, it's even written here. Where the Lagos State tenancy does not apply, Apapa Ikeja GRA. Can you see that?
Yes, sir.
It's clear. So you can see here, these premises is governed by the Recovery of Premises Law 1973. Why? Because it's at Ikeja GRA. It cannot be governed by the tenancy law of Lagos State. As a yearly tenant commencing from May 1st, 2022, at a rate of 10 million naira per annum. Mr. Chinedu, so the next thing you're supposed to look at is the rent. No, the duration. This is yearly. You put that one side. The next thing is the rent. Let us say the magistrate court has jurisdiction. What is the monetary value of the magistrate court?
10 million.
10 million.
Good. So does the magistrate court have jurisdiction if it's 10 million naira here?
Yes, sir.
Okay. But I said let's say, because you know that naturally the magistrate court is not supposed to have jurisdiction, quote and unquote, in these areas because they are brought pursuant to the Lagos State Recovery of Premises, right? But of course, the magistrate court that still has jurisdiction. All those ones they are saying is unnecessary. So at the rate of 10 million naira per annum, Mr. Chinedu is owing 2 years' rent as well as frequently organizing parties at the house, contrary to the tenancy agreement. Infuriated by Mr. Chinedu's breaches of the tenancy agreement, the landlord instructed you on the 1st of February 2025 to terminate the tenancy and evict the tenant. He wants a declaration that Mr. Chinedu has breached the tenancy agreement and order granting the landlord to enter and repossess the land as well as arrears of rent and men's profits. the appropriate court to institute this action to get expeditious judgment. Hey, what's the answer, ladies and gentlemen? What's the answer?
Magistrate Court of Lagos State. Magistrate Court of Lagos State.
Why is it not the Rent Control Tribunal?
No, I don't know about that one.
Yes, what's the answer? Precious want to quickly look at that one.
No, be
Yeah,
so
I
I'm
choose
looking at
D.
my own work.
What's the answer?
Yeah, I chose High Court. So
No, it cannot be High Court. Now,
I chose
High Court
magistrate court.
has jurisdiction. I agree with you, right? Any matter that the Magistrate Court has jurisdiction, the High Court has jurisdiction. But the only problem is you don't go to the High Court if you want the matter to be done expeditiously. For example, there is a particular matter that I'm appearing against Templars. Templars is the counsel on the other end, right? And it's a tenancy matter, but it's a tenancy where the rent is, I think, close to 50 million. So it's a big matter, right? Now, it's before Justice Oresoya. I appeared before Justice Oresoya, and I told Justice Oresoya that, oh, we have served the defendant. Templars is here. Give us a day for hearing. Hearing means for trial. And then all of a sudden, Justice Oresoya adjourned the matter from last week, June 8th or June 7th or something. Adjourned the matter to October 8th. October, from June to October 8th. For what? For mention. And I'm like, what are we doing here? Even though I tried to convince him that no, let us adjourn for trial, blah, blah, blah. He adjourned for mention. 3 months, 4 months adjournment. This kind of adjournment is not what you will find at the magistrate court. No magistrate court is going to adjourn a matter from June to no. The highest you are going to see a magistrate court adjourn is 1 month, 2 months. And that 2 months is probably for trial. Magistrate court usually adjourns in 3 weeks, 4 weeks, and things like that. So when you see that they asked a question, there was a part here that you should have known. When they said to get expeditious judgment, it means they are telling you, we know that the High Court, you can bring the matter to the Lagos State High Court, but we want a more correct answer. The expeditious there tells you that it is the Magistrate Court of Lagos State. They intentionally put Ikeja GRA and put that Rent Control Tribunal. That Rent Control Tribunal, yes, you are supposed to take it there, but it has been abolished by the tenancy law of Lagos State. Do you understand? So it doesn't apply anymore, right? The customary court, or anybody that chose customary court, they are supposed to flog you out of law school. I don't know why you think customary court has jurisdiction in this case. So it's, of course, Magistrate Court of Lagos State, D. Do you understand that? Does everybody understand?
Yes, sir.
Does everybody understand?
Yes, sir.
Yes, sir.
Okay, very good. Now, the defendant failed to respond to the originating process and he was equally absent on the day fit for hearing without legal representation. The most appropriate order the court can make. Who is this one that is selecting the answer? The most appropriate order the court can make in the circumstance is the claimant to proceed to trial, enter default judgment against the defendant. The person even got it wrong. Enter summary judgment or award cost. What's the answer?
B.
Once they hear that the person got it wrong, they don't know what to say again because they are not really choosing that.
I said B.
B. Did you say B?
Yes, sir.
Yeah, defend your answer. Defend your answer.
Okay, so
Michael, defend your answer.
okay. The reason I chose B is because you ask for default judgment when the defendant fails to do an act that he was meant to do. Here, they did not respond to the originating process, and neither did they on the day fixed for hearing. They were not available. So
Okay.
the best thing the claimants can do is to ask for default judgment, except where what he's seeking for is declaratory relief. That is when you ask the court to set it down for trial.
Go to the question.
Sir?
Go back to the question. I like the last part that you said. It shows that you are very intelligent. Because when we were talking, I was like, okay. Then you not said, except where is a declaration you leave. I said, yeah, go to the question. Go and look at it. What is stated there? Read 4 lines to the end. He wants a what?
Oh, he said he wants a declaration.
Uh-huh.
Yeah, he has to set it down
You
for trial.
think that when law school sets the question, they don't know what they do? You think they don't know what they are doing? He said before judgment.
I didn't read that part.
Where there is a declaration, and that's
Very
what
true.
law school wants. That's what law school wants to feast on. They want to feast on you not looking twice. See, I like the fact that you are sharp in thinking, Michael. But when you see a question, that's why I said, look at 2 questions. For example, look at these 2 options now. Look at these 2 options. Summary judgment, you just know that one is saying rubbish. Summary judgment in rent case, the tenancy case. Award cost could be, but it's not the most appropriate at that point. Those A and B, this thing. Now, before you make that decision next time, Michael, you don't make the decision on an assumption that, it's going to be different. Go up again. You already know the exceptions in your head, except where there is a declaration. Go up again and satisfy yourself that there is no declaration before you make this decision. Do you understand that?
Yes, sir.
That is how it is done. You don't, because those are the mistakes that at the end of the day, when you come out, you know this thing, you know you are very smart, you know that you read this thing, you know it very well. But somehow, when the result came out, you're like, what is going on? These are the things that happen. So you have to be very, very vigilant. Do you understand?
Yes, sir.
Okay. So one of the following notices must be served on Mr. Chinedu to effectively terminate his tenancy. Now, this is where the confusing part ends. Starts rather. So can someone tell me what the answer is?
Where is the option? Okay. This more notice of quittance. I don't even remember the date in the question.
We can go back to the date. That's not an issue. So this is
but there's something that is going on in our court. Although they gave us the assignment and I've not gone through it. They said there is a Supreme Court judgment that said there's no need for all these 6 months and whatever. That the only thing that is required now is 7 days owners.
I don't know where you brought that Supreme Court judgment to, but it's not in your. Don't carry it inside law school. You will fail. I don't know where you got the Supreme Court judgment, but you will fail. According to law school standards, 6 months this can do for yearly tenancy. That one that they are telling you, go and put it somewhere, that is for practice. When you get to practice, you begin to do jurisprudential analysis. In law school, we don't do jurisprudential analysis here. It's what they teach you that you must obey. This one way, I don't know where they carry 6 months they come. but it's a good thing that you are taking note of what is going on in the courtroom. I'm just saying that be wary of what you impute into your law school knowledge, right? I mean, take note of what is going on. That's very, very good. But just be very, very careful, because these people will put things they're not supposed. Even myself, you know how I am straining myself to make sure I don't go outside law school when I'm teaching. I'm trying to look at the provisions, the part of the so 499 of go to 499.
Yes, sir.
So we are talking about length of notice and expiration period. Section 13 of the Lagos State Tenancy Law provides that what? Where there is no stipulation as to the notice to be given by either party to determine the tenancy, which means that the parties can actually determine the length of notice, first of all. But law school usually doesn't ask question on this part. The following shall apply. A week's notice for a tenant at will. You know who a tenant at will is. No, it's just there at the pleasure of the landlord. A month's notice for a monthly tenant. 3 months notice for a quarterly tenant. 3 months notice for a half yearly tenant and 6 months notice for a yearly tenant. Now, please note, ladies and gentlemen, especially Priscilla, the Supreme Court judgment was probably made in pursuant to another law of another state. The Supreme Court judgment cannot be in context of Section 13 of the Lagos State law, and then it will say that the 6-month notice does not apply. Again, the Supreme Court judgment could mean that the 6-month notice will not apply if the parties stipulated that it would not apply. So there are a lot of things that you have to read before you come to that conclusion that there's a Supreme Court judgment that says that the 6-month notice will not apply. So that's why I say be very, very careful. So now, the nature of tenancy shall, in the absence of any evidence to the contrary, be determined by reference to the time the rent is paid or demanded. 1 minute. So, considering the provisions of the law above, the following distinction can be drawn. Let us read the one for Abuja, where there is no express stipulation as to the notice to be given by either party to determine the tenancy. The following periods shall be given. In the case of a tenant at will or a weekly tenancy, a week's notice. In the case of a monthly tenancy, a month's notice. In the case of a quarterly tenancy, a quarter's notice. And subject to subsection 2 of this section, in the case of a yearly tenancy, have a year's notice. Now, there may be a distinction between half a year's notice and a 6-month notice, but let's look at it. Under Recovery of Premises Act Abuja, there is a provision for both tenants at will and weekly tenants, and they are entitled to a week's notice. While under the Lagos State Tenancy Law, only tenant at will is provided, and such a tenant is entitled to a week's notice. Also, the Lagos State Tenancy Law, unlike the Recovery of Premises Act, provides for yearly tenant who is entitled to 3 months notice. On the expiration of notice to quit, the Supreme Court in so and so. Wait, I want to go to the part that.
I think a quit notice is supposed to be given at the expiration of the if at the if of
Yes,
to the
yes,
expiration.
yes. So I think it's in 501, right? 501. Considering the position of the law above, a notice to quit is to expire on the eve of the anniversary of the current term or the last day of the tenancy. For example, note that this is Abuja. This is Abuja. So, for example, if a yearly tenancy takes effect from January 1st, a quit notice in respect of the tenancy is to expire 30th of December 2019. If it's a month notice, blah, blah, blah. I want to look for that of Lagos. Now, go to 502. Now, section 13 sub 4 of the Lagos State Law. Okay, more so, under the Lagos State Law, a notice to quit need not expire at the eve of the current term. This is where the question is coming from, ladies and gentlemen. Are you following me?
Yes, sir.
Good. This is where the question is coming from. Right? Now, but there is something that I'm not certain about. But let's continue first. Now, in the Lagos State Tenancy Law, the expiration need not be at the eve. The eve means a day before the end. So, for example, if your tenancy starts 1st of January, the eve of your tenancy is 31st of December. Do you understand that?
Yes.
Yes, sir.
Okay, good. In Abuja, any notice to quit that you are drafting must expire 31st of December, the eve of the end of that tenancy. So, which means that, let us look at this question again. If this question is saying that the tenancy commenced when? May 1st, 2022. Tell me, if it's in Abuja, our notice to quit must end when? Who can tell me?
December.
Jesus Christ of Nazareth. How is that if?
It will start
April
December
30th,
to end
2023.
To
Thank you.
amend April.
Priscilla, it cannot be December now. We are saying the if of
No,
May.
I thought when it will be issued. That is all you asked.
Oh, okay. Okay, December, January, February, March, April. It cannot still be December, sef. It's going to be issued maybe in November, but that's not the question. We're asking for when it's going to expire.
It's supposed to last for 6 months, right?
Yes, so November, December, January, February, March, April. Yes, so you are supposed to issue it in November.
Okay.
Yes. So it's supposed to expire April. Is April 30 days or 31 days?
30 days.
30.
No, I think 30 days are September.
April, June, and November. It is 30 days.
Okay, it's 30 days. So 30 days, 30th of April also. So if it's in Abuja, whatever notice to quit you have to draft must end 30th of April. No be me talk am o, is in your textbook o. Shebi we read it together just now.
Yes, sir.
You go to
So the time person will now be calculating.
501. Considering the position of the law above, a notice to quit is to expire on the anniversary of the current term or the first day of the tenancy. For example, if a yearly tenancy takes effect from January 1st, 2019, a notice to quit in respect of the tenancy is to expire when 31st of December 2019. Simple. Now, but then when we go to Lagos, more so under the Lagos State Tenancy Law 2011, a notice to quit need not expire at the eve of the current term. Section 13 sub 4 of the Tenancy Law of Lagos State provides that notice for tenants under sub 1 CDE of this section need not terminate at the anniversary of the tenancy, but may terminate on a date of the expiration of the tenancy. Now look at this. Unlike the Recovery of Tenancy Act, what is important is the redundancy, is the adequacy of the length of tenancy and not the date of expiry. Under the Recovery of Tenancy Act, Abuja, in the case of a yearly tenant, the tenant shall not expire before the time when crops grow on the land. That one is why are we talking about crops and plants? Okay, so you can see in Lagos, what Lagos is concerned about is you give 6 months notice, maybe you no give 6 months notice, you give up. But what Abuja is concerned about is not only did you give 6 months notice, did it expire on the eve of that tenancy, which to me is the definition of stupidity. Because I will not start doing calculation as lawyer. Oh yeah, so when did you issue? When will it expire? When will it? It doesn't make sense. You can literally issue at any time. So let's come back to this question now, right? So the question says, where is it? One of the following notices must be served on Mr. Chinedu to effectively terminate his this thing. Now, this one says notice to quit can expire anytime preceding it after the date. Let us leave A first. A seems like a potential answer. D says 7 days. Just strike that out. Strike that with all alacrity. Strike it out. C says 6 months notice to quit must end 30th. Must end on the 30th of April. Keep it because it's conterminous with what we can have in Abuja. So keep it. Then look at B. 6 months notice. 6 month notice dated February 2nd, 2025. Wait, let me.
The date. What of the dates in the 15B, the 15C, 2026 that is there?
Which one?
16, the C.
Okay. I just want to. You can see that I'm scrolling up. I want to look at the date that this thing was instituted again to be sure of what I'm doing. Right. So, if related by Mr. Chinedu's breach of tenancy agreement, the landlord instructed you on first to terminate the agreement and evict Okay, to terminate the tenancy and evict the tenant. First, so the instruction was given February 1st, 2025. Okay. So 6 months notice must end 30th. One minute. Let me go back up.
Yes, what is May 1?
Huh?
February, March, April, May, June, July.
C is not the answer because of the words must end. Do you understand? Because it's
Yes.
Lagos State. It must not end. Yes, it can end, but it must not end. Yes, it's not a must. That's why I'm disqualifying C. Now, the date there is irrelevant because they did not tell us the date that the suit was instituted. If they had told us the date the suit was instituted or the date that it was served, and we look at time frame and it's less than 6 months, date can be relevant. But date is not relevant. The only thing that was relevant was when the instruction was given. The instruction was given February 1st. So,
Yes.
That
I mean,
if it is that if
yes,
it is in Abuja, I think that February you cannot serve the quick notice again because it will not expire on the
yes, I agree with you. I agree with you. But this is not Abuja, this is Lagos.
This is Lagos. The answer is B.
This is Lagos.
I just want to clarify. I just want to be clear on that.
Yes, you are very correct. If it were Abuja, but it doesn't apply here, right? So we cross out D, we cross out C because C says must end. So we have A and B. Now let us look at B. 6 months notice to quit, dated February. Yes, it can terminate it. If the 6 month notice dated, it can. There's nothing wrong with it, right? There's nothing wrong with it. Let me look at the question again. But the most correct answer is actually 6 months notice to quit, which can expire anytime. Proceeding, I don't understand the proceeding it after the date of renewal of the tenancy. What is that?
Preceded me before after the date of renewal of the tenancy.
Oh,
before the
proceeded
date.
it after. I don't understand this A, honestly. What does it mean? Proceeded it after the day.
Now, from what I'm thinking, I think he's saying that he's talking about
if it was given before the date of renewal.
Time of the anniversary of the tenancy, or the time you renew, the day you pay your rent.
It doesn't. That is not necessary for. The reason why I'm confused is because of the word proceeded.
Yes, because from here it says that, from what you read earlier, it says it may terminate on or after.
Yes.
By saying proceeded, it's after. That means it's already saying it must be after, and this one is saying
exactly
before or after.
Exactly. So I don't know why they say can expire anytime on one hand, and then now go further to further confuse me and say proceeded it's after. What is proceeded? So that disqualifies A in my view.
Yes. So
do you understand? It disqualifies A in my view, right? Because if you are maybe the proceeded was an error. Maybe they are trying to say provided.
Yes.
Provided it's after the expiration. Provided it's after the date of renewal of the tenancy, and if that is what they are saying, then it is entirely wrong. Because in Lagos, it can be served at any time. Nothing like is after or before, anytime. So the most correct is actually B, which is 6 months notice to quit, dated 2nd, 2025. Because it's not wrong. It's 6 months notice to quit. The date was after the instruction, and there's nothing disqualifying it, basically.
Yes, sir.
So do you guys see how I answer questions? I want you to learn how to answer questions like this. You can see that I kept on going back to the question again. Let me see, what am I going to use to disqualify this one? I don't know. What will I use to? You have to have a basis for disqualification. And
Yes, sir. Yes,
note
sir.
that it is very time constrained, but your skill and knowledge, there are some questions that you will know that this was just a time waster. And again, when you see question as to date, the number of days and something, once you don't know it, don't waste time. Don't waste time, because you don't know it, you don't know it. For example, what is it called? A number of days for election, for you to bring an action for election is 21 days from the date that the result was announced, right? If you do
Yes.
not know it's 21 days, don't bother, because you just waste your time. So for the ones that you know, cross check so that you can get the answer, so that you don't miss the one that you're supposed to know. Now, when judgment has been delivered in favor of the claimant, the most appropriate means of recovering possession is what? Warrant of FIFA, writ of FIFA, warrant of possession, judgment summons, writ of possession. What's the answer?
Writ
Warrant
of
of
Unit of
possession.
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 I'm going to give this as an what is it called? I'm going to give it as an assignment for everyone, whether or not it's writ of possession or warrant. I
Now,
want you guys to
what
go
to
and
do?
read judgment, enforcement of judgment. Go and read it. Why is it writ of possession and not warrant? Why is it warrant of possession and not writ? Go and
Yes.
read it. Assuming this case is in Abuja, the enforcement procedure above must be valid for what?
Sir,
Number 20.
we don't know. I don't know it, sir.
That's why go and read enforcement of judgment. Please, Michael, take note of these things I said you guys to go and read so that by next time we
Yes,
can
sir.
discuss it. So, um, for 19, Lola, I just saw your question. I said everybody should go and read it. For 20 is piggybacked upon 19. So go and read that too as well. In our next class, we'll talk about it. It's under enforcement of judgment. Try to match up with these things. When I say go and read it, go and read it, right? You would appreciate that fact, right? So with this, we had already used a lot of time. We've used close to 4 hours. It's already 3 hours plus. So I can see that Precious is extremely tired. She has had all waves of tiredness. She has yawned severally. She has stood up, walked around the room severally. She has sat down and squeezed her face when somebody was giving an answer that she was like, what did this person dey talk? You know, all forms of expressions of tiredness. Now she has left the camera to so I know we are all tired actually, and it's a good thing that we are here, right?
I'm texting
But
you.
before what do you say?
No, what she wrote, I just replied to it. She says like
It's
we've
like
done introduction in all the topics. If I
we have
go
not
back, if they
done.
are taking those topics, I will just be looking at them.
Okay, so yeah, that's one of the reasons why I told you guys before you got the course that I would try as much as possible to at least touch some things in these courses that I didn't teach on the channel, right? So that at least you will not, when you are picking up the book to read for the first time, it will not sound like German. At least in appeal now, there's something called appealers of rights. There's something called appealers of leave. Abi, you know that there are days too, and you have to be careful about those days for appeal, right? One is
Mm.
there are two different types of judgment. There's final judgment, there's interlocutory judgment. These are things that you have to take note of when you're reading appeal, right? Even though we have not gone deep, but at least the key elements you are noting them. For election petition, at least you know now that there are pre-election matters that are to be instituted at the Federal High Court, Abi, and you know what will constitute pre-election matters and things like that, right? And the number of days to which pre-election matter must be done, 14 days, right? And things like that. So when you go to read those topics now it will sound so French-like or German-like in nature, right? Which is one of the
Yes, sir.
reasons why we have get-togethers like this.
Yes, sir.
So I think that we should have this more often. Uh, and more constant, if you guys would agree.
Sure,
Although,
sir.
what do you say?
I guess surely, sir, we agree.
Okay, so although my time, but now that I've spent about 40,000 naira to buy this Zoom recorded class, I would actually have time so I don't waste it for the next 1 month, right? I'll provide time for it and have as many sessions as we can have. And maybe 1 or 2 sessions will actually have a draft class as well. But the only thing is that for our draft class, it might be on laptops. Like you guys may have to draft on laptops and then share your screen. I don't know how that's going to work because it will make more sense if I just say, okay, everybody drafts something and you quickly draft it, and then I can look at your screen and say, oh, okay, this part should be better, that part, and everybody's seeing the screen together and the correction is going on together. You are learning and it helps better. But I hope that we get it right. So, is there any question before we call it a day today?
Yes, sir.
Yeah.
Sir, there is something we were arguing about in my court. They said a case is adjourned for plea, and someone is saying there is nothing like case being adjourned for plea. I don't know if you can say something about that.
Is that a criminal case?
No, even civil. They said the case is adjourned for plea or is slated for plea.
I don't know what you mean by even civil. What do you mean by is your court a magistrate court?
There is a magistrate court.
Plea.
Yes,
They,
plea
when,
like
when, when you say when you say plea, there are two things that comes to my head. Is either you are saying plea bargain, which is usually done in a criminal matter where the defendant would try to cut some kind of deal with the prosecution to have a reduced sentence or something, or
No, this
it's
is not plea
another.
of whether not guilty or plea of non-liable. That
There's
no,
nothing like
that cannot be.
non-liable. There's nothing like non-liable. Not
So
guilty,
that I
guilty or
take
not
the
guilty.
court.
Is guilty or not
They'll say
guilty. There's
plea of
nothing like non-liable.
non-liable for civil. Plea of not guilty is for criminal.
Omo, I don't know why you're saying this. Which jurisdiction are you in?
Is the Odumaya your room Odumaya in Port Harcourt?
Your room, Maya. Really, please. This has nothing to do with Lagos. We don't do that here, and we don't do that for the sake of law school. I think it's peculiar to that court as a result of their magistrate court rules. Their magistrate court
Okay,
rules
okay.
there can provide for plea because I know that what you say when the defendant is about to take his plea, you adjourn for arraignment for the sake of law school, criminal matter. The day that the defendant is taking his plea is the day the charge is read. The day the charge is read to the defendant is the day the defendant is arraigned. It's called
Oh,
arraignment. So this is the first time I'm hearing that there's something like a plea of not guilty and plea of not liable. What if you are not liable for something? You draft your statement of defense now. Why are you coming to tell the court you are not liable? Put the
I don't
particulars
know.
of your non liability in your statement of defense. That's what you do now.
So
Do you understand?
yes, sir. Yes, sir.
Yeah. So I think it is peculiar to that jurisdiction. It's not a law school issue. Yeah.
Okay, sir. Thank you,
Room
sir.
or Dumaya. Okay. Any other question before we call it a day?
None for now.
Okay, it has been a very wonderful time with you guys. I hope we have this more often. Make sure you read, and to the Lolas of this
Thank you
world that
so
will not
much,
show
sir.
their camera, and the Jola and the Feoluwa that will keep jumping in and jumping out, and the Farida that was here ab initio and did not say a word throughout, and the Chibuzos iPhone that also joined Farida not to say a word throughout. I hope to see you guys at the next time. Michael, please
Yes, sir.
continue your reading. You are
Yes, sir.
showing very serious potentials, especially for civil. But please
Yes, sir.
hope that the same potentials you have for civil, you are also exploring that potential for other areas. Don't stay in civil alone. No.
Yes, sir.
What shall it profit a man to know only civil and get D or C in ethics or in property? Please, make
Yes,
sure
sir.
that you go far and wide. Precious, Lola, Lola is all she want to whine. He say, God, let me have potentials too. You, Precious, stop hiding now. Show your face. Okay, sorry guys. Omodola is a scholar. Don't let her deceive you as you think that she's not. She's a very big scholar. So I'll see you guys next week. I'll give you the details as well. Have a very beautiful evening and a fruitful week ahead. Bye.
Thank you very much, sir.
Thank you.
Bye.
Bye.
Thank you.
Bye bye.